been deprived of due to a simple misinterpreted comment posted online. Reagan Klein and Sawyer Smith were friends since the 8th grade, and any reasonable person can interpret this comment as just another way of two friends having a hasty argument. On August 14th, Reagan posted a comment on Sawyer's social media page that was perceived as threatening. However, Your Honor, my client has the right to utilize his free speech and be able to speak out his opinions of another person, even if it is considered rude. Your Honor, the defense respectfully requests that the motion be granted and count 2 be dismissed due to the following reasons. There was no intent to harm. There lacked immediacy in carrying out the supposed threat, and the supposed victim was not in sustained fear.
I'm going to ask you to repeat. I got number 1. What's number 2?
There lacked immediacy in carrying out the supposed threat, and the supposed victim did not sustain fear.
Thank you. Go ahead.
Essentially, for a true threat to be required, a true threat requires an intent to harm the person that the threat is aimed at. For example, in the case of DC versus RR, the defendant had posted grotesque and cruel details of their intentions to inflict harm on their victim. Unlike our client, Reagan Klein, his comment was very vague and unspecific.
In the pretrial motion, I'd like to be specific about the facts of your case, all right? Mm-hmm. So what's the statement that you're trying to tell me was not harmful? What statement did he make?
Well, he had stated, I am going to get you. Along the lines, he had stated, you deserve to die. I am going to get you. Watch your back, sir. I'm coming for you.
And you're telling me that that statement does not pose harm?
No, it doesn't, Your Honor. May I proceed?
Go ahead.
So, Your Honor, like I had stated before, Reagan's own comment was very vague and unspecific, unlike the case of DC, in which the grotesque comment, any reasonable person can interpret that as a life-threatening comment. As for in our case, Reagan's own comment was blunt and rather said in a jocular tone rather than in a serious expression.
So differentiate the case law facts for me from your facts. How is it different? Because when I just hear the words that your client said, that certainly sounds to me like he's trying to pose harm. So what's the difference factually between the case law and your case?
Well, the difference is that Reagan's own comment was vague. It can be interpreted in many ways that are not violent. I'm going to get you, watch your back. Doesn't really say anything, doesn't really follow up with any plan or any intention to actually commit harm on Miss Smith. May I proceed?
And what about the case law you just used?
Well, DC, they had stated, I want to rip out your heart and feed it to you. In addition, they also said, I want to pound your head in with an ice pick.
So you're telling me there's a difference in these two statements?
Yes, because in DC, it was very grotesque, very cruel, very detailed. Rather, in our case, it was very vague and inspecific, and it can be interpreted in many ways that are not violent. May I proceed? Furthermore, Reagan's comment should be perceived as free speech because there lacked immediacy in carrying out the supposed threat. Both parties were in their respective households. Reagan was in fact spending the night eating pizza with his friends, while Sawyer was streaming a movie. Therefore, when the comment was posted, there was no immediacy in following up with what the supposed threat had mentioned. In the case of Envy Ricky T, the student had told their teacher, similar to Reagan's comment, I'm going to get you. The court had ruled that the student's comment was in fact protected speech because the student failed to have any immediate prospect following the threat. The student had no gravity of purpose, similar with Reagan, because he simply just posted the comment after feeling overwhelmed.
So in the case of the student and the teacher, did the student have access to the teacher to cause immediate possibility of imminent harm?
Yes, Your Honor, the student was face-to-face with the teacher at the time. May I proceed?
And your client was not face-to-face with the victim here?
No, Your Honor. The client was simply having a cyber communication, an online communication between Ms. Smith. May I proceed?
Yes, please.
Lastly, Ms. Smith did not sustain any fear whatsoever. Although she had stated in her witness statement that she was in fear, this had only occurred after her own swatting incident, given the fact that she was injured at the time. However, at the moment that the comment was posted, Ms. Smith was streaming a movie. She was in her bed. And she replied back to Reagan's own comment stating, LOL, as if you're done now. Bye. Your Honor, LOL, which stands for laugh out loud, clearly indicates that Sawyer did not feel attacked or threatened in any way when the comment was posted. Therefore, Your Honor, because there lacked immediacy, there was no intent to harm, and Ms. Smith did not sustain any fear, the defense respectfully requests that the motion be granted and count 2 be dismissed.
At
Thank
some
you.
point, I'm going to ask a couple of questions.
Yeah.
I'm sorry, you're not done.
It's okay.
All right, so your claim is that the victim in this case, we're going to call it the alleged victim, right?
Yes,
The alleged victim did not have sustained fear, is that right?
correct.
And the only reason you're stating so is because the alleged victim responded LOL?
Correct.
Is that the sole purpose of why you believe so? Are there not facts for me to rely upon that says, in fact, she was in fear? Did she not subsequently expose herself as being fearful?
She did, Your Honor, but she also had the opportunity to contact authorities, contact anybody for that matter when the comment was posted. However, she failed to do so. Instead, she was in her bed, as stated in her fact pattern, that she was streaming a movie when she received the comment.
So her not contacting police is what you're stating I need to rely upon to say that she wasn't afraid?
Yes, Your Honor, and although in People v. Chandler, the victim in the case had tried to hide her fears due to the defendant having threatened her with a golf club, that is different from our case. Because in our case, both parties were on the opposite side of town. Reagan failed to actually have any threatening gestures, and they failed to have any purpose or any thorough plan that indicated that they would intend harm on Sawyer.
Thank you.
Thank you. No further words, Your Honor.